you're denied benefits after being terminated for allegedly committing misconduct, then the employer will need to show that you violated some rule or policy of the company. Note that this applies to your last employer and your next to last employer. So you may need to address what happened with your past two employers. So first, what is the rule or policy the employer is saying you violated? If it can't come up with one or doesn't provide a copy of it if it's written, then you want to be sure to point that out to the referee. If the employer does identify a specific rule or policy, then it needs to provide evidence that you actually violated that rule or policy through testimony, documents, or other evidence. If it can't, then you should win. Now let's talk about a few important points. Misconduct has to be a deliberate violation of the employer's rules. So if you didn't know you were violating a rule or didn't intend to, then it shouldn't be misconduct. Now, if you don't intentionally break the rules but completely disregard the employer's standards of behavior, then that can count as misconduct as well. Ordinary negligence in isolated instances or good faith errors in judgment or discretion are not misconduct. In other words, if something minor happens one or two times, or you are honestly doing your best and made a mistake, then that shouldn't count as misconduct. Poor performance shouldn't be misconduct if you're simply unable to meet the employer's expectations. However, if you knowingly fail to perform your duties or are repeatedly warned you need to do better and don't try to improve, then that can count as misconduct. In the end, the employer needs to show there was an element of wrongfulness, meaning you did something wrong and either knew it was wrong or were so negligent or disregarded the rules so badly that it should be considered misconduct. There's definitely some gray area here where the referee will have some discretion, so you want to present your case in the best way you can to show you didn't knowingly do anything wrong. Keep in mind that it's the employer's burden to show you committed misconduct, and it wouldn't hurt to remind the referee of that fact during the closing statement you give. Now consider a few more things. The referee will focus mostly on the final incident that led to your termination. If that incident occurred weeks or months before your termination, then the referee would likely determine that it couldn't have been the reason for your termination. Also, in most cases, the employer would need to show it disciplined you when it found out about the alleged misconduct, not weeks or months later, because that would tend to show it didn't think the violation was very serious. The referee will also look at whether the rule you violated was enforced against all employees or just against you, meaning it was selectively enforced. He or she will also consider whether the employer condoned your actions by, for example, failing to discipline you in the past for the same violation. If the employer has a policy of progressive discipline and doesn't follow it, then that will be taken into account as well. If the employer has a handbook of rules and policies, you'll want to look in there to see if there's a discipline policy it didn't follow, and if so, provide that as evidence. Of course, if you committed a clear, egregious violation of the employer's policies, then it doesn't necessarily have to show it warned you first and otherwise disciplined you before terminating you, although it could depend on what their written policy on discipline says. So these are all factors the referee could consider when deciding whether you committed misconduct. In the end, you want to do whatever you can to show you didn't do anything wrong enough to be denied unemployment benefits. Let's finish with a quick example. If the employer says you were terminated because you took too many breaks, then it would need to show it has a specific policy about how many breaks employees are allowed to take and when. It would also need to provide proof of how many breaks you actually took by presenting time records or testimony from your supervisor or other evidence. Now, let's say that the company policy allows 2 breaks per day, and 3 weeks before they terminated you, you took 3 breaks in one day. But that's the only time you violated the policy. You'd want to present evidence showing that you didn't take too many breaks any other days, and that you weren't disciplined at any other time for taking too many breaks. If true, You'd also want to show they said nothing about violating the brakes policy until you were terminated, which shows they must not have been too serious about it. You'd want to argue that you only violated the policy one time, which is an isolated incident and isn't bad enough to count as misconduct. Or maybe you can show the only reason you took an extra break that day was because of a family emergency or something similar. So you had no intent to violate the policy and had a really good reason for doing it. In other words, you want to show that all things considered, you didn't really do anything wrong, at least not intentionally, or if you did, it only happened one time. This is only one brief hypothetical example, but I hope it helps you see the kind of things you need to prove to win if you were terminated for alleged misconduct.